Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just me today. So today we're bringing you an extra special bonus episode of the very recently released Fraser and Canada. It's the latest in our Section 15 jurisprudence, which we've got up on the website. Go and check out the other Section 15 decisions, and in the meantime, enjoy this one. It's a good one. The following are the reasons delivered by Justices Rowe and Brown. Part 1, Introduction. At one level, this appeal presents the simple question: is tying pension benefits to hours worked discriminatory? The RCMP allows 2 or more of its regular members to share one full-time position through the option of job sharing. The pension benefits of members who job share, like all other members, are determined through the Royal Canadian Mounted Police Superannuation Act and the Royal Canadian Mounted Police Superannuation Regulations. Under the plan, the pension benefits of members who job share are prorated to reflect the hours they worked during the job sharing period. In addition to job sharing, the RCMP has also given its members the option of taking leave without pay. These members may buy back pension benefits when they return to work from an extended period of leave without pay. Through its job sharing policy and the leave without pay provisions, the RCMP has sought to provide flexible working arrangements in recognition of the burden women face in pursuing a career due to the unequal distribution of childcare responsibilities in society. For members with childcare responsibilities, job sharing accommodates those who are able to remain operationally connected to the force and want to keep their policing skills up to date, while leave without pay accommodates those who temporarily leave the force by enhancing their ability to return to work without undue financial hardship. The plan and the RCMP's policy on job sharing are not anathema to the vision of equality that underlies Section 15 of the Charter, but instead represent an attempt to accommodate employees in light of their particular circumstances. And yet, our colleague Justice Abella finds these aspects of the plan to be unconstitutional. She describes the historical disadvantages women have faced in the workplace, and then concludes in effect that the plan does not do enough to remedy these disadvantages. One may reach this conclusion as a matter of policy, but that is not the question to be decided. Rather, and at its most fundamental level, it is whether, as a matter of law, the Constitution empowers or even requires the courts to substitute their views as to how to remedy those disadvantages for those of the legislature and the executive. The circumstances here are extraordinary in that it is acknowledged that Parliament was not obliged to enact the plan, nor is it barred from repealing it. But is not the next extension of our colleague's line of reasoning that governments, federal and provincial, have a positive duty under Section 15(1) to initiate measures that will remove all effects of historic discrimination, and that they are constitutionally barred from repealing or even amending such measures? These are profoundly complex matters of public policy that no Canadian court is institutionally competent to deal with. Our colleague's line of reasoning in this case lies the groundwork for just that position. Among other things, it effectively overrules this court's recent statement in Alliance that the state may act incrementally in addressing systemic equality. That the plan does not eradicate disadvantage should not mean that it should attract censure as discriminatory. Rather, considered in its entirety and with proper attention to its object, the plan is a package of benefits designed to balance the needs of some RCMP employees during their child-raising years, prorated according to hours worked. On any permutation of Section 15, its effect surely cannot be to hinder government efforts to address pre-existing inequality. This leads to a more fundamental concern presented by this appeal, a concern which we observe has been repeatedly made by legal commentators, but which has yet to be taken up by this court. The gauge of substantive equality by which this court has measured Section 15(1) claims of right, not having been defined except by reference to what it is not, i.e., formal equality, has become an open-ended and undisciplined rhetorical device by which courts may privilege, without making explicit, their own policy preferences. As we explain below, and with respect, this case is an instance of that inherent malleability being deployed so as to strike down a scheme which was, after all, designed to be ameliorative. The impugned provisions of the plan are not unconstitutional. For the reasons that follow, we would dismiss the appeal. Part 2. Facts. While we agree generally with the facts as recounted by our colleague, we would add some observations regarding the appellant's employment status. Further, her description of the plan obscures some key aspects of how it functions. This is not a small matter. Understanding the plan and the underlying legislative scheme in its entirety is key to adjudicating the Section 15 claim. As this court has explained, quote, where the impugned distinction is the denial of a benefit that is part of a statutory benefit scheme that applies to a large number of people, the discrimination assessment must focus on the object of the measure alleged to be discriminatory in the context of the broader legislative scheme, taking into account the universe of potential beneficiaries, end quote. Subpart A, the appellant's employment status. Our colleague does not directly engage with the appellant's employment status. At paragraph 21, she notes that the appellants argued that the pension plan, properly interpreted, allows participants in the job-sharing program to acquire full pension credit. This passage refers to an issue before the federal court. The appellants argued that job sharers were presumptively full-time members who agreed to work temporarily reduced hours, or that they would work full-time with periods of leave without pay. This argument was also advanced before this court, and, having considered this issue in detail, the federal court found that the appellants worked part-time while job sharing. This finding was based on a thorough review of the record, including the 1997 bulletin that introduced job sharing, the RCMP administrative manual, and the appellant's memoranda of agreement. We highlight that the manual explicitly states that job sharing is considered part-time employment. Further, the federal court expressly rejected the arguments that job sharers were partly on leave without pay or worked full-time with temporarily reduced hours. The Federal Court of Appeal upheld these findings, noting that the federal court's conclusions on this point were largely factual. Applying a standard of palpable and overriding error, it found no basis to interfere. Despite this, our colleague repeatedly refers to job sharers as full-time members who temporarily reduced their working hours, or full-time RCMP members who job share. She therefore seems to overturn this finding without setting out the applicable standard or explaining the error. This finding is key to the rest of our colleague's decision. By treating job sharers as full-time employees, she is able to say they are entitled to the same pension benefits as full-time employees. With respect, this approach skates over key aspects of the plan, most notably how it treats part-time members and the different situations in which members take leave without pay. In other words, our colleague does not account for the context of the entire scheme, which she must do in order to be faithful to Whitler. Subpart B, the operation of the plan. At the outset, it is important to note that the appellants do not allege that it is unfair in general for members who work part-time to have their pensions adjusted for periods of part-time work. Rather, the core of their argument is they should be able to buy back pensionable service in the same way as members who take leave without pay, a submission we discuss below. To properly assess this submission, it is crucial to understand how the plan operates and, in particular, how it applies in the same manner to full-time and part-time members, except to make adjustments to account for hours actually worked. The plan is a contributory defined benefit pension plan, which means that contribution rates are based on a percentage of a member's earnings. Both members and the RCMP are required to contribute to the plan. A member's pension is determined based on the years of pensionable service, that is, the period of service credited to a member at retirement. All members accrue pensionable service at the same rate, regardless of whether they work part or full-time. This means that 1 year of part-time work and 1 year of full-time work both count as 1 year of pensionable service. This important nuance is missing from our colleagues' reasons, which speak only of full-time pensionable service. The only employment statuses provided for under the plan are full-time, part-time, and leave without pay. The regulations define full-time member as one who is engaged to work 40 hours per week. Meanwhile, a part-time member is described as a member who is engaged to work a minimum of 12 hours per week and is not a full-time member. Importantly, there are no specific provisions relating to job sharing in the plan. This makes sense given the relevant policies define job sharing as a form of part-time work. Job sharers are therefore treated as working part-time during the period in which they job share. All members contribute to the pension fund at the same rate, set by Treasury Board as a percentage of their salary. Upon retirement, members receive a pension benefit that is proportional to the assigned hours of work. The benefits are prorated to account for any part-time service. As the respondent's pension expert explained, this approach aims to ensure that part-time members and full-time members are treated equitably by tying pension benefits to assigned hours of work. Members of pension benefits are based on the average annual pay received for the 5 best consecutive years of highest paid pensionable service. For periods of part-time pensionable service, the average annual pay is based on the full-time equivalent of the authorized rate of pay and is then prorated to reflect the hours actually worked. The respondent's pension expert explains that this method ensures that members will not be penalized based on when in their career the part-time service occurred. As we will discuss, the core of the appellant's argument focuses on the buyback option available to members who take leave without pay. It is therefore also important to understand how the buyback option works. Members who take leave without pay have no assigned hours of work and are therefore not remunerated but maintain continuity of employment. For the first 3 months of a leave without pay period, members must contribute to the pension fund the amount they would have contributed had they been working. Following that period, members may elect not to contribute for some or all of the balance of the leave without pay period. However, members who choose to treat the remaining leave without pay period as pensionable must pay 2 or 2.5 times the amount they would have paid had they been working. This is what is meant by buying back pensionable service. Crucially, pension benefits for members who take leave without pay are determined based on status they held immediately before taking leave without pay. In other words, members who worked part-time prior to taking leave without pay and buy back that pensionable service will earn a part-time pension benefit for the period of leave without pay. As the foregoing shows, members who buy back pensionable service following a period of leave without pay are making contributions for periods in which they did not work. Conceptually, therefore, it makes sense to say that they are buying back that time. In contrast, members who job share make pension contributions throughout the job sharing period. We therefore agree with the respondent that it is inaccurate to speak of buying back service when it comes to job sharing. The hours worked while job sharing are already fully pensionable. There is no remaining time to be bought back. Job sharers work part-time hours and received part-time pension benefits for the period they job shared. The appellants, however, are seeking to obtain a full-time pension benefit in respect of a period where they have worked part-time hours. To be clear, no other members are entitled to such a benefit. Even members who take leave without pay are limited to the hours they worked prior to taking leave without pay. Example, the part-time member who takes leave without pay is able to buy back part-time, but not full-time pension benefits for their time spent on leave without pay. The appellants are, in this sense, asking to be put in a better position than everyone else under the plan, and indeed under any of the other 10 public sector pension plans. Our colleague elides this vital point, which underlies our reasoning and undermines hers. Instead, she draws attention to the fact that members who are suspended can obtain full-time pension credit. The RCMP's administration manual does state that the period of time a member is suspended without pay and allowances will count as pensionable service. But there is almost no evidence before the court as to how this works. It may be that the member who worked part-time prior to a suspension is entitled to only part-time pension credit, which would seem to align with how the plan otherwise works. We simply do not know. Moreover, during the hearing, the respondent stated this option is no longer available and has not been for some time, noting that the document relied on by the appellants dates back to 2003. It is not appropriate to ascribe any significance whatsoever to the situation of suspended members given this evidentiary void. In short, it is incumbent upon this court in judging the constitutionality of the plan to understand and account for how the scheme operates as a whole, rather than compare options that are available to different groups line by line. And, considering the plan as a whole, it is clear that it accommodates various stages of a member's life and career. It is meant to be flexible and meet different needs at different times. Part 3. Analysis. The appellants say the plan violates Section 15 of the Charter in its application to members who job share by denying them the right to accrue full-time pension credit for periods when they job shared for childcare reasons. In our view, it does not. We stress in coming to this conclusion that the court is not called upon to decide whether the plan represents good or bad policy on the part of Parliament in the legislation and the executive in the regulations. The task of the court, rather, is to assess whether the plan respects the bounds of the constitutional obligations imposed by the state. Section 15 protects individuals against state-imposed discrimination. Like any other charter right, it applies to the actions of the state and not to private acts of discrimination. In the case at bar, the appellant's claim is premised on the relationship between their sex, the allocation of childcare responsibilities in society, and the fact that they job shared. Their argument is that, because primary responsibility for childcare has historically fallen upon women, the plan ought to have allowed them to buy back additional pensionable service for the time they job shared to fulfill their career responsibilities. It is indisputable that women have historically been disadvantaged in the workplace in part by the demands of childcare. This court has recognized this disadvantage, notably in matters of compensation, in Alliance and Central. In this case, the application judge was presented with, and accepted, evidence showing that women continue to assume traditional roles in the home and that women are more likely than their male counterparts to scale back at work and respond to role overload and work-life conflict. She also accepted evidence that women continue to make up a larger proportion of the part-time labor force, particularly between the ages of 25 and 44, when they are most likely to be raising children. Further, the Federal Court of Appeal has described systemic discrimination as a continuing phenomenon which has its roots deep in history and societal attitudes, and cannot be isolated to a single action or statement. And it exists within the private and public spheres. Some aspects of government employment policies, for example, have contributed to women's systemic disadvantage. However, many private sources, that is, long-standing phenomena other than government policies, also contribute to women's ongoing systemic disadvantage. A clear example of this is how parents share and expect each other to share domestic responsibilities, including childcare. In the present case, the plan represents neither a public nor private source of ongoing systemic disadvantage. It does not contribute to a woman's systemic disadvantage, nor does it reinforce, perpetuate, or exacerbate the pre-existing disadvantage of women in the workplace which arises in part from unequal distribution of parental responsibilities. Rather, it seeks to ameliorate, although without eliminating, the effects of that pre-existing disadvantage on women's careers in the RCMP by providing employment options which allow them the flexibility to continue to pursue their careers while raising children. This case therefore raises the question, can a court strike down part of a statutory scheme for simply being insufficiently remedial? In our respectful view, as we explain below, it cannot. Subpart A, Step 1 of the Section 15 analysis. As our colleague explains, this claim alleges adverse impact discrimination. We agree that the Section 15 test, as it is framed, can address such claims. That test consists of the following 2 steps. 1. Does the law on its face or in its impact create a distinction on the basis of an enumerated or analogous ground? 2. Does the law fail to respond to the actual capacities and needs of the group and instead impose burdens or deny a benefit in a manner that has the effect of reinforcing, perpetuating, or exacerbating their disadvantage? That the test can account for adverse impact discrimination is shown by its inquiry into whether a law creates a distinction in its impact. As this court recognized in Whitler, in adverse impact cases, the claimant will have more work to do at the first step. The concept of a distinction has been central to our Section 15 jurisprudence since Andrews and the Law Society of British Columbia, which described discrimination as a distinction, whether intentional or not, but based on grounds relating to personal characteristics of the individual or group. As the court explained in Whitler, quote, inherent in the word distinction is the idea that the claimant is treated differently than others. Comparison is thus engaged, in that the claimant asserts that he or she is denied a benefit that others are granted or carries a burden that others do not, by reason of a personal characteristic that falls within the enumerated or analogous grounds of Section 15(1), end quote. As this passage demonstrates, the focus at Step 1 upon identifying a distinction is consistent with the comparative nature of equality. Indeed, and as this court has repeatedly emphasized, equality is an inherently comparative concept. Comparison is relevant throughout both steps of the Section 15 analysis. Despite the comparative nature of equality, however, this court has cautioned that seeking out a mirror comparator group is not the proper method to evaluate Section 15 claims. As stated in Whitler, the analysis is contextual, not formalistic, grounded in the actual situation of the group and the potential of the impugned law to worsen their circumstances. Nonetheless, the identification of a distinction is crucial. Our colleague identifies a distinction between job sharers and full-time members who work regular hours, who are suspended, or who take leave without pay, while failing, as noted, to consider individuals who work part-time prior to taking leave without pay. Yet she later rejects, at least facially, a comparison to members who take leave without pay, dismissing it as formalistic and mirror comparator group analysis, maintaining that job sharers are entitled to substantive equality relative to full-time members. As we explain below, however, it becomes evident upon closer examination that her rejection of a comparison to members who take the leave without pay is only superficial. The existence of the buyback provisions for members who take leave without pay is the very reason that she finds a breach. Absent that basis for comparison, the alleged breach disappears. As noted, Step 1 of the Section 15 analysis considers whether there is a distinction in impact. A search for impact is a search for causation. The inquiry here is into whether the gap in outcomes is fully explained by pre-existing disadvantage or whether state conduct has contributed to it. In other words, Section 15 is concerned with state conduct that contributes to, that is, augments, pre-existing disadvantage. Further, the analysis is directed to the effects of the challenged law or action on the claimant group. While disadvantage may persist with or without the impugned law or state action, a demonstration that has the effect of contributing to that disadvantage is necessary. Establishing causation is particularly critical in instances where the state acts in order to address systemic discrimination. In such cases, policies that narrow a gap may fail to close it. Despite our colleague's view to the contrary, this court made clear an alliance that the state does not have, by virtue of Section 15, a freestanding positive obligation to remedy social inequalities. Moreover, when the state does act with such a purpose, it can do so incrementally. Quote, the result of finding that Quebec's amendments breach Section 15 in this case is not, as Quebec suggests, to impose a freestanding positive obligation on the state to enact benefit schemes to redress social inequalities. Nor does it undermine the state's ability to act incrementally in addressing systemic inequality. But Section 15 does require the state to ensure that whatever actions it does take do not have a discriminatory impact, end quote. This is consistent with the general focus of Section 15 as explained in Quebec and A. If the state conduct widens the gap between the historically disadvantaged group and the rest of society rather than narrowing it, then it is discriminatory. These clear and recent statements of this court should mandate dismissal of this appeal. Our colleague overcomes the requirement of causation and these statements by relaxing the claimant's evidentiary burden to the point of insignificance. She posits that evidence of statistical disparity and of broader group disadvantage may demonstrate disproportionate impact, although she adds that neither is mandatory and that their significance will vary depending on the case. With respect to broader group disadvantage, a single claimant's own evidence or even judicial notice is all she requires. While courts must evaluate evidence in light of the proof which it was in the power of one side to have produced and in the power of the other side to have contradicted, ultimately the onus is on the claimant to establish causation. In many contexts, subjective anecdotal evidence is simply incapable of meeting this objective onus. Our colleague's relaxed approach also risks overlooking the interests of public good. With respect to statistical disparity, our colleague contends that clear and consistent statistical disparities can show a disproportionate impact on members of protected groups, even if the precise reason for that impact is unknown. In this case, then, because there is a statistical disparity between women and men with respect to who has taken advantage of the job sharing program, and because there is evidence that women have historically borne a greater part of childcare responsibilities and formed a greater proportion of the part-time labor force, she finds that the law has a disproportionate impact on women. With respect, this analysis is unsound, since it assumes that correlation between the number of women who have taken advantage of the job-sharing program and evidence of disproportionate childcare responsibilities falling upon women is the function of causation, whereas it might well be the function of independent factors. Correlation itself is not proof of causation. Indeed, where one is dealing with complex social and economic considerations, like sex and employment, one can readily assume that there are many factors involved, some of which will give rise to causation while others will simply be the result of coincidence, that is caused by independent factors. But it is causation that must be demonstrated between the law and the disadvantage. It is not enough for our colleague to refer to statistical disparity and a broader group disadvantage. Indeed, the presence of a statistical disparity is precisely what is to be expected where a law is enacted, as the relevant portions of the plan were, to incrementally narrow a pre-existing systemic disadvantage. When the law fails to completely eradicate such disadvantage, an element of disparity will obviously remain. It follows that to accept statistical disparity and broader group disadvantage as sufficient to demonstrate that a law creates a distinction in impact is to do away with this court's statement made only 2 years ago in Alliance that Section 15 neither imposes a freestanding positive obligation on the state to redress social inequalities, nor undermines the state's ability to act incrementally in addressing systemic inequality. It would also represent an undisciplined judicial expansion of the scope of Section 15, which does not apply to private acts of discrimination, because it would render the state responsible for discrimination it has not caused. We turn now to the appellant's argument that the plan, on its face or in its impact, draws a distinction based on not just the enumerated ground of sex, but also on family status or parental status, which they argue should be recognized as an analogous ground. We agree with our colleague that it is inappropriate to recognize an analogous ground solely for the purpose of this litigation. Not only is this inappropriate, this approach was squarely rejected in Corbière and Canada, Minister of Indian and Northern Affairs. We also agree that because this case can be resolved on the basis of the enumerated ground of sex, it is, substantially for the reasons she gives, unnecessary and unwise to consider parental or family status. The recognition of an analogous ground has significant implications as it opens up the possibility of new lines of charter claims. Once an analogous ground is recognized, it always stands as a constant marker of potential legislative discrimination. Recognition of further analogous grounds should be left for cases where there is sufficient argument and evidence and where it is necessary to do so. It should not be done on an ad hoc basis. Focusing then on the enumerated ground of sex, there are two ways in which a distinction can be framed in this case. Each is based to some extent on comparison, which is to be expected given the inherently comparative nature of Section 15. But neither is based on the mirror comparator group approach rejected by this court, in which the comparator mirrors the characteristics of the claimant or claimant group relevant to the benefit or advantage sought, except for the personal characteristic on which the claim is based. In other words, these distinctions do not look for a situation that is in every way identical to the claimant group, except for the enumerated ground. Our analysis, rather, is contextual, considering the various facets of the plan and the evidence that is available on the composition of RCMP membership. The first distinction can be drawn by looking to full-time members. Job sharers, unlike full-time members, do not obtain a full 40 hours of weekly pensionable service. The distinction is said to be based on sex because members of the job sharing program are disproportionately women, whereas uninterrupted full-time employment is a male pattern of employment. We agree that a distinction is shown here. A second way of identifying a distinction in this case is by comparison to members who take leave without pay. Our colleague expressly rejects this as the relevant comparison. Nonetheless, she begins her analysis by stating that unlike full-time members who work regular hours, who are suspended, or who take unpaid leave, full-time RCMP members who job share are classified as part-time workers under the regulations and cannot obtain full-time pension credit for their service. In other words, the reason that our colleague finds a distinction is based on a comparison to members who take leave without pay. If the option to buy back pensionable service for periods of leave without pay did not exist, the distinction would vanish. Further, and as we have already observed, not all members who take leave without pay have the right to receive full-time pension credit for their service. Only members who were working full-time hours before taking leave without pay may do so. Throughout her reasons, our colleague fails to account for this nuance. In any event, the substance of this alleged discrimination is that, with respect to pensionable service, job sharers are limited to the number of hours they work per week, while members who take leave without pay are not, as they have the option to buy back pensionable service. But this distinction is not based on sex. There is no evidence that members taking leave without pay are less likely to be women than members participating in the job sharing program. As the Court of Appeal noted, there was very little evidence about the number of RCMP members who have opted to job share or to work part-time, and no evidence about those who have opted to take an unpaid leave of absence. Nor was there any evidence to suggest that more men than women or more childless individuals than those with children had opted to take leave without pay. Further, the RCMP's Administration Manual 2.5 on leave recognizes various approved reasons for leave without pay: education, spousal relocation, care and nurturing of preschool-aged children, and personal needs. Our colleague cannot simply assume, without evidence, that job sharers as a group are more likely to be women than members who take leave without pay. Both options are specifically but not exclusively available for women. Therefore, the distinction between job sharing and leave without pay is not based on an enumerated or analogous ground. The analysis fails at step 1. However, bearing in mind that we have found that the comparison between job sharers, who do not obtain a full 40 hours of weekly pensionable service, and full-time members who do, qualifies at the first step of the Section 15 analysis as a distinction based on sex, we turn to the second step. Here, given the contextual nature of the analysis, taking leave without pay into account remains important. Subpart B, Step 2 of the Section 15 analysis. Having shown that the plan creates a distinction that, in its impact, is based on sex, the second stage of the Section 15.1 analysis asks whether that distinction is discriminatory, in that it fails to respond to the actual capacities and needs of the group and instead imposes burdens or denies a benefit in a manner that has the effect of reinforcing, perpetuating, or exacerbating the disadvantages of women. This court has said that historic disadvantage plays a significant role in identifying substantive discrimination. Substantive discrimination, however, cannot be reduced to historical disadvantage. In some circumstances, laws can maintain significant disadvantage while treating individuals equally and without discrimination. For example, securities and property legislation represents state action that supports a system of private property ownership. Where the distribution of private property between men and women is unequal, this legislation allows that unequal distribution to persist. Nonetheless, the legislation is not discriminatory. Under our colleagues' approach, the second step of the Section 15 test serves only to check if the unequal impact of a law impacts a historically disadvantaged group. There is no analysis of whether the unequal impact corresponds with a group's actual circumstances or needs, or whether it is in any other sense substantively discriminatory. Though substantive discrimination has been described differently over the years, it has always required an element of arbitrariness or unfairness. This element has been most often expressed as a failure to respond to individuals' actual capacities, needs, and circumstances. For a time, perpetuating prejudice and stereotyping were seen as essential features of substantive discrimination. More recently, a more contextual analysis has been preferred, because arbitrary discrimination need not take the form of promoting negative attitudes. Howsoever it has been expressed, this element of arbitrariness or unfairness has never been confused with a discriminatory purpose. A discriminatory purpose can indicate substantive discrimination, but it is not required to establish it. Substantive discrimination is focused on effect rather than intention. The academic literature cited by our colleagues supports requiring an element of arbitrariness or unfairness to establish discrimination. It indicates that, while discrimination need not be intentional, it is fundamentally a form of wrongful behavior. Our colleague now suggests, however, that the sole focus of the substantive discrimination analysis is historical disadvantage, and that any factors relating to arbitrariness or unfairness must be confined to the Section 1 analysis. This robs the substantive discrimination analysis of its purpose, departing significantly and without acknowledgement or justification from decades of jurisprudence. Our colleagues' removal of considerations of arbitrariness or unfairness from the Section 15 analysis has far-reaching consequences for this appeal. As we identified above, a distinction arises based on sex when comparing members who job share to members with male pattern employment, that is, members who work 40-hour weeks throughout their careers. Because the pension benefits of members in the job-sharing program are prorated to reflect the lower number of hours they worked, they receive a lower level of pension benefits than members with a male pattern of employment. Pension benefits are best viewed as part of a whole compensation package, as they are a form of remuneration. In this case, members who job share receive no additional compensation to offset their lower level of pension benefits. On the contrary, they receive lower pay as well as lower pension benefits, because both pay and pension benefits are tied to hours worked. Our colleague suggests that offering a lower level of pension benefits to members in the job-sharing program perpetuates a long-standing source of economic disadvantage of women relative to men. This disadvantage, she says, cannot be justified on the basis that job sharers choose to work fewer hours. We accept that in most contexts, choice cannot protect differential treatment from a finding of discrimination. In this case, however, the logical extension of our colleague's argument is that if other part-time members, i.e. those in arrangements other than job sharing, are predominantly women, as it has been suggested, they too are entitled to substantive equality relative to full-time members in matters of compensation. Are all part-time members therefore entitled to the option of contributing to the plan as though they were full-time members? Herein lies the significance of our colleagues' relegation of considerations of arbitrariness or unfairness to the Section 1 analysis. It is not, in general, discriminatory in an arbitrary or unfair sense for an employer to prorate benefits according to hours worked. Employers are expected to treat employees equally within the context of an employment relationship that is predicated on an exchange of work for compensation. Prorating compensation, including benefits, according to work is not arbitrary or discriminatory when it responds to employees' actual capacities and circumstances. But even were we to take our colleagues' recasting of the Section 15.1 analysis as legitimate, her open-ended approach leaves much to be desired as a matter of logic. For example, if, as she says, it is discriminatory towards the appellants to tie pension benefits and other compensation to hours worked, why stop at allowing part-time and job-sharing members to buy back additional pension benefits? After all, full-time members do not have to buy back their pensions. On our colleagues' logic, if hours worked are not relevant, then part-time and job-sharing members should receive a full-time pension without buying back hours. And if compensation cannot be tied to hours worked, then part-time and job-sharing members should receive a full-time salary as well. Taking our colleague's argument to its natural conclusion shows the vast implications of her position. One searches in vain for a logical or rational stopping point to either the entitlements that would flow from her line of reasoning or the scope of judicial intervention to award them. Conversely, we posit simply that employers must be able to compensate employees based on hours worked. This is our central point, which our colleague does not attempt to answer. While prorating pension benefits according to hours worked is not in itself discriminatory, it might be so on this court's jurisprudence if some groups of employees were to receive more favorable treatment than others, where such treatment reinforces, perpetuates, or exacerbates disadvantage. As we have discussed, the distinction based on members who job share compared to those who take leave without pay is not based on sex. However, in accordance with the contextual analysis of the broader scheme mandated by Whitler, the leave without pay provisions remain an important consideration at Step 2. We accept, as our colleague says, that the proper analysis, as it was described in Whitler, must not devolve into a narrow comparison between members who job share and those who take leave without pay. There is, however, a degree of inconsistency in our colleague's approach, as she states that members who job share are entitled to substantive equality to members with a male pattern of employment, and yet focuses her comparison on members who take leave without pay, who, unlike members with a male pattern of employment, have the option to buy back additional benefits. This is made plain by our colleague's remedy. She does not require that all part-time members should have the option of buying back the same pension benefits as full-time members. Rather, this option is made available only to those who have temporarily reduced their hours, like those on a leave without pay. It is, therefore, the presence of the leave without pay and buyback rights for members on leave without pay that render the plan unconstitutional for our colleague. Leave without pay is the linchpin of her decision. With respect, this is contrary to the contextual approach mandated by Whitler. Job sharing and leave without pay are options that may be valuable to members at different points in their lives and careers. Job sharing allows members to continue to work with reduced hours, while leave without pay allows members to maintain continuity of employment without working. Each of these programs represents a package of benefits and responsibilities designed to balance the needs of the employer and of members at various stages of their careers. It is inappropriate to cherry-pick particular elements out of such packages and compare them in isolation, seeking line-by-line parity. Instead, a contextual analysis must consider the full packages and ask whether the lines drawn are generally appropriate, having regard to the circumstances of the persons impacted and the objects of the scheme. Perfect correspondence between a benefit program and the actual needs and circumstances of the claimant group is not required. In other words, the focus must be on the actual impact of the law in its full context. Each benefit program will have its advantages and drawbacks. While members who take leave without pay must pay the employer contribution for any pension benefits they buy back, the employer makes contributions for job shares for each hour they work. While members who take leave without pay receive no pay, job shares receive income for the hours they work. The option to buy back pensionable service is an attractive feature of the leave without pay package, and it is understandable that members in the job sharing program might want it. But on the whole, the record does not suggest that the leave without pay package confers improved financial security or pension benefits when taking into account the job sharing program as well as continuous full-time employment. Nor does it suggest that the lines drawn are inappropriate, having regard to all the circumstances. Offering pension benefits that are prorated to hours worked is not substantive discrimination, and it does not become substantive discrimination because members who take leave without pay have the right to buy back hours of pension benefits. As a result, Section 15.1 of the Charter is not infringed, and there is no need to consider Section 1. Subpart C. Practical implications. While the foregoing is sufficient to dispose of the matter, we wish to highlight the practical implications of our colleagues' reasons for judgment. Governments must be afforded the latitude to act incrementally when addressing a deeply ingrained, complex, and persistent social phenomenon such as inequality. This assumes that the inequality arises from factors in society, where the government itself has created the inequality. Matters are, as we have already indicated, somewhat different. There are processes by which a government must set its priorities, allocate its budget, and obtain parliamentary approval of its programs. In designing legislation to address a particular equality issue, a government can draw on far more internal and external expertise than we judges can. As a result, it is better positioned than we are to appreciate the consequences of a particular course of lawmaking, both upon society and upon public resources. With these practical realities in mind, we must also recognize that, were a government expected to remove all inequalities for all groups on every occasion it acted, it may be disinclined to act, given that any remedial scheme will inevitably be under-inclusive in some respect. Governments would understandably become reluctant to create any new remedial benefit schemes because their limits would depend on an accurate prediction of the outcome of court proceedings under Section 15.1 of the Charter. To avoid this chilling effect and to encourage governments to enact remedial legislation addressing pre-existing disadvantage, this court has until now judiciously accepted that governments may implement reforms one step at a time and address the reforms to the phase of the problem which seems most acute to the legislative mind. The focal point in assessing remedial legislation is not to ask whether the government has met the gold standard, but to recognize that the government, quote, should not be obliged to deal with all aspects of a problem at once. It must surely be permitted to take incremental measures. It must be given reasonable leeway to deal with problems one step at a time, to balance possible inequalities under the law against other inequalities resulting from the adoption of a course of action, and to take account of the difficulties, whether social, economic, or budgetary, that would arise if it attempted to deal with social and economic problems in their entirety, assuming such problems can ever be perceived in their entirety." End quote. At the risk of repeating ourselves, we stress that, as recently as 2 years ago in Alliance, the Court affirmed this commitment to judicial restraint by permitting the government to address pre-existing disadvantage incrementally. And so it bears repeating that Alliance stated that first, there is no freestanding positive obligation to remedy social inequities, and secondly, that the state is entitled to act incrementally to address such inequities. That is precisely what the impugned provisions of the plan represent, an example of a government acting incrementally to address inequalities that exist in society when it has no obligation to do so, using provisions that do not in themselves have a discriminatory impact. Like our colleague, we note that both the leave without pay buyback provisions and job sharing option are ameliorative. Under this court's statement of the law in Alliance, these provisions should be upheld. Our colleague disagrees. Under her approach, legislation must not simply be favorable or beneficial, but sufficiently so to achieve substantive equality. Section 15.1 is breached because the plan, though part of a remedial scheme, perpetuates, that is, fails to remove, economic disadvantage for women. In other words, the plan is insufficiently remedial. The practical effect of this decision is to abandon the foundational principles so recently affirmed in Alliance and to discourage governments from offering ameliorative programs, or, as in this case, employment options to its employees in the future. This is because our colleague has, in effect, imposed a positive obligation on legislatures, where they attempt to merely ameliorate the effects of inequality, to eradicate those effects altogether. Such an obligation exceeds the ambit this Court has given Section 15.1, which, unlike certain other provisions of the Charter that appear to compel government action, like Section 3, 14, 20, and 23, does not impose upon governments the obligation to take positive actions to remedy the symptoms of systemic inequality. Requiring that legislation be sufficiently remedial not only changes the scope of Section 15.1, but also pulls courts outside their institutional competence. The judiciary is ill-equipped to grapple with the public policy and budgetary complexities in legislating benefit plans. Advancing the cause of human rights invites a measure of deference for legislative choice. This is because only legislatures have the institutional capacity to conduct the research and study necessary to assess how, and at what pace, its resources should be applied to most effectively address a particular pre-existing equality issue, and ultimately to oversee that implementation. Courts are not well placed to define the nature and scope of an obligation to enact sufficiently remedial legislation. Consider this plan, for example. In light of our colleague's decision, what is to stop an RCMP employee from working full-time for a very short time before entering a job-sharing agreement? That employee would apparently be permitted to buy back full-time pension benefits, whereas the employee who entered the force as a part-time member and has since remained part-time will not. Relatedly, what does it mean for employees to temporarily reduce their hours? What if an employee entered a job-sharing agreement to care for her children, but did not return to full-time work once her children became adults? Of course, we do not know these things, and we cannot know them. Nor are we expected to know them or even anticipate them. But for that same reason, we are expected to keep to the limits of our institutional competencies, and not fiddle with the complex mechanics of legislative schemes like the plan. In the case at bar, any disadvantage the appellants face is caused not by the impugned provisions or any government action, but by the unequal division of household and family responsibilities and social circumstances such as the availability of quality childcare. The solution to addressing these underlying matters, which exist outside of the plan and the purview of courts, is surely not to strike down remedial legislation. In our colleague's view, however, these true causes of the disadvantage are entirely irrelevant. She allows for judicial intervention whenever a court is able to identify in the case before it a related social circumstance it wishes to address. Courts are now empowered to engage in transformation of the law if they simply believe that institutions and relations must be changed. Respectfully, we say this is not our role. A related and final point on the practical implications of our colleague's decision. For 30 years, this court has struggled to define the term substantive equality. An intelligible and principled definition continues to be elusive. Indeed, this case illustrates the difference posed by the slippery quality of substantive equality, the core value of our colleague's decision, and its constant shifting in this court's jurisprudence. While the court has stated that substantive equality is not formal equality, it has said little to address what substantive equality is. Scant guidance has been offered beyond describing substantive equality as the animating norm, goal, approach, engine, and now the philosophical premise of Section 15.1. Metaphor and ascription has prevailed over actual definition. Commentators have taken notice. Quote, "It is essential for this court to frame a conceptually rigorous understanding of substantive equality as it operates in Canadian equality jurisprudence. There has been no comparable agreement on substantive equality as a state of affairs. i.e., what a situation in which the ideal is instantiated through law would look like, as opposed to the ideal's methodological dimension. Nor has substantive equality been given a positive definition by the court. Rather, it has been defined negatively as an approach to Section 15.1 contrasting with a formal equality approach." End quote. Others have gone further, for example, noting that despite the efforts of many scholars to flesh out the precise requirements of substantive equality, this court's elaboration of the same has been sketchy and occasionally contradictory. To be clear, we do not seek to overturn the jurisprudence that our colleague recounts in her reasons. Rather, we aim to give effect to it. Our disagreement is about the meaning and requirements of substantive equality. We view her approach as lacking in the clarity and guidance necessary to give effect properly to the Charter's purposes, notably with regard to legislation that is fundamentally ameliorative. It is for this reason that we highlight the lack of a substantive definition surrounding the norm of substantive equality in this court's jurisprudence. The concept has not been defined in a manner that renders Section 15 rights, or even the criteria by which they are adjudicated, knowable in advance by claimants in the state, or applicable with any consistency by courts. This lack of definition ex ante is antithetical to any notion of judicial restraint. Where a legal test lacks defined bounds, courts applying it exercise truly arbitrary powers of review. And that is the point at which we have arrived with substantive equality. It has become an unbounded, rhetorical vehicle by which the judiciary's policy preferences and personal ideologies are imposed piecemeal upon individual cases. Consider our colleague's approach here. Legislation that is ameliorative in both intent and effect is judicially reconfigured because it is not ameliorative enough, or more precisely, not ameliorative in ways our colleague would prefer. It is also a prime example of how the goalposts of substantive equality are constantly on the move, evidenced most clearly by our colleague's abandonment of the prudent guidance in Alliance regarding incremental measures to alleviate systemic inequality. Indeed, her approach in this case lends support to Professor Young's damning criticism that substantive equality is an unelaborated, cryptic guidepost, pointing to the equality outcome the author prefers. Justice Oliver Wendell Holmes's observation, made in Baldwin and Missouri, regarding the U.S. doctrine of substantive due process is also apostate. Quote, "As the decisions now stand, I see hardly any limit but the sky to the invalidating of those rights if they happen to strike a majority of this court as for any reason undesirable. I cannot believe that the 14th Amendment was intended to give us carte blanche to embody our economic or moral beliefs in its prohibitions. Yet I can think of no narrower reason that seems to me to justify the present and the earlier decisions which I have referred." End quote. The result of all this is corrosive of the rule of law. Our colleague wonders aloud what our definition of the rule of law is. We share the views of jurists such as Lord Bingham and Appeal Justice Sharp. The concept of the rule of law has interlocking components. One is pertinent here. Canadians should be governed by rules stated and knowable in advance that enable them to guide their conduct. As Appeal Justice Sharp writes, quote, "The Supreme Court has insisted that there must be an intelligible standard, capable of providing an adequate basis for legal debate, as to its meaning by reasoned analysis applying legal criteria. In Irwin Toy, the majority wrote that where there is no intelligible standard, and where the decision-maker has been given a plenary discretion to do whatever seems best in a wide set of circumstances, the essential minimum requirements of the rule of law are not met." End quote. Our colleague's appeal to stare decisis, we say with respect, therefore misses the point. The issue is not whether this court's Section 15 jurisprudence should be respected. The issue, rather, is whether that jurisprudence, as she has interpreted it, states a standard that is practically knowable and reasonably predictable as to results. In our view, the concept of substantive equality has become so vague that it is impossible for claimants or legislatures to anticipate its demands in advance. Legislatures are, in effect, expected to hit a moving target, as the court continues to revise its analytical approach to Section 15.1 without ever overruling or even really disapproving of its earlier judgments on the aspect of those judgments that have now been reversed. This revisionist approach, the constant moving of the goalposts of substantive equality to suit judicial preference, will undoubtedly continue to cause further confusion. This suggests another, less normative but more practical concern. If the demands of substantive equality could be predicted, governments might actually be able to comply with them. Instead, quote, in the view of many commentators, the equality jurisprudence, despite the court's self-identified efforts to establish clear interpretations, has been muddled and inconsistent. Put simply, it lacks the coherence to offer serious guidance about how to realize substantive equality on the ground, end quote. In other words, legislatures can comply only with rules they can know well enough to abide by. How can a legislature know what any given court will determine to be sufficiently remedial? The immensity of the obligation that our colleagues foist upon legislatures and governments, in both its unpredictability and in the amount of resources it requires, is such that none of them can reasonably be expected to bear it. This wholly disregards Justice Laforet's apt admonition in McKinney that inequality issues cannot even be fully understood, let alone remedied, all at once. The failure to properly define the scope of Section 15.1 also has the practical effect of pushing the bulk of the analysis to Section 1. As a result, courts are not to engage in a substantive analysis of discrimination where they have a comparative advantage relative to the legislature, but rather in the evaluation of policy, where they do not. This fails to attend to the limits inherent in Section 15. By their very nature, the demands of equality cannot be determined without considering the needs and circumstances of persons and groups in addition to the claimant, including the practical, moral, economic, and social underpinnings of the legislation in question. Otherwise, we risk allowing for the intermediate conclusion of a right infringement to trade on the higher prestige and greater strength of a moral right that provides an undefeated reason for action, watering down the significance of a finding of Section 15.1 infringement beyond recognition and requiring the state to justify even its most trivial decisions. In defining substantive equality, courts must bear in mind two considerations. First, Section 15.1 cannot actually guarantee equality in the broadest sense throughout society. Systemic disadvantage is just that, systemic, being rooted in social attitudes and institutions. This does not mean that systemic discrimination cannot or should not be addressed. Rather, it simply means that Section 15.1 is limited in its capacity to do so. Section 15.1 responds only to state action, and judicial review of state action is ill-suited to implementing the kind of wide-ranging institutional or policy changes that are necessary to fully address systemic disadvantage. That this is so becomes apparent when one considers that all of the reports cited by our colleague are directed towards government, not court action. Secondly, bringing analytical discipline to Section 15.1 must start by reaffirming that equality is an inherently comparative notion. While mirror comparators have proved unworkable, the analysis must be imbued with a measure of comparison in order to avoid what our colleague now endorses: the unbounded, unpredictable search for inequality. To all this, our colleague suggests that we, and by extension, those scholars and judges who have questioned the utility and meaning of the court's jurisprudence on substantive equality, advance a straw man argument for which at root is an argument for formal equality. But again, with respect, it is our colleague who marshals a straw man argument. Our reasons apply an approach to substantive equality firmly rooted in this court's jurisprudence, including alliance. The conclusion we reach was shared by all 4 lower court judges, who tried to apply this court's jurisprudence to the facts of the case. Our colleague, on the other hand, casts aside paragraph 42 of alliance as a useless strand and sidesteps Whittler's call for a contextual approach, which notably arose precisely in the circumstances of a pension scheme. In fact, her reasons are entirely devoid of any consideration of the approach to pension schemes necessitated by Whittler. Indeed, more telling than what our colleague does say in response is what she does not say. Notably, she does not explain what substantive equality means, save by references to what it is not, formal equality. She fails to define substantive equality in terms that allow its meaning to be understood so that the requirements of Section 15 can be practically knowable and reasonably predictable in advance. Thus, loosely defined, substantive equality is almost infinitely malleable, allowing judges to invoke it as rhetorical cover for their own policy preferences in deciding a given case. Such vast and little bounded discretion does not accord with, but rather departs from, the rule of law. Part 4. Conclusion. As we see it, the sole reason the plan is being judicially reviewed is because Parliament and the government tried to be accommodating in their employment options. If they had not offered pension buyback rights for members who take leave without pay, there would be no basis for judicial intervention at all. The upshot of our colleagues' reasoning is that the public is now burdened with new financial obligations, simply because Parliament and the executive dared to address pre-existing inequality incrementally, instead of taking more radical measures to eliminate it. In the future, they may well reason that inaction is a safer route. Similar issues will undoubtedly arise with any other social welfare legislation or government attempts to remedy systemic disadvantage. By reserving the right to arbitrarily second-guess and undo any legislation that attempts to incrementally address systemic disadvantage, the court makes it more practically difficult for legislatures and governments to implement policies that promote equality. Put simply, we see restricting the government's ability to incrementally address disadvantage as a peculiar way to promote equality. We would therefore dismiss the appeal.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.